Okay, now we look at 87, right? So generally when we talk about mistake, right? So what is mistake? That means, is the contract entered into first? Has the contract been entered into? Yes. Okay, so that means the contract has been entered into because of certain aspects, because of certain issues, then the contract becomes void or voidable for mistake, right? But generally it can be void ab initio. So when we say void ab initio means what? It is void right from the beginning, right? So void ab initio basically means void right from the beginning, right? So that is very important for you to identify. So that means, first of all, contract already done. Then you found out that there has been a mistake. Okay? So now there are basically two aspects of it. One is common mistake. So the types of mistake, as I said, one is common mistake. So with regards to common mistake, we shall look at the point relating to subject matter not existent. Right? So that's called res extincta. That means the subject matter is non-existent at the time the contract was made. Can you recollect the facts of Couturier and Hastie?
Before the vessel reached the port, the corn has already been sold.
Right. So actually there was basically an agreement to sell the corn, right, on board the vessel, right? The buyer and the seller both want to sell one fellow want to sell, the other fellow want to buy, both agreed. But at the time when the contract was made, the corn was no longer on board, right? Because it has already been sold before by the master, because he felt that there was the corns were getting a bit stale and he has to sell, so he sold. So on that basis, there was a mistake between both parties, right? So as there was a mistake between both parties, then what happened? The contract specifically highlighted the point, right? The courts highlighted the points that at the time when the contract was made, there was no particular goods in place. So therefore, the contract is what? Void for mistake. So void for mistake means you cannot enforce the contract. So both parties are not liable, right? So that's why I say it is void for mistake. And that is the case of Couturier and Hastie, as stated in page 87. Right? Then you have, right? Then there are other cases which you can also look at. But if you look at the other case, right? The case of Mercury and Commonwealth disposals, that also we talked about how it was interpreted differently in the House of Courts. That means what the main factor is, right? If you look at 88 on the first part, Martin B, the judgment part, Martin B ruled that the contract imported that at the time of sale, the corn was in existence as such as capable of delivery, and that as it had been sold, the plaintiffs could not recover, right? So the judgment was affirmed. Okay? So that was the point. But when you look at the other one, Mercury and Commonwealth disposal, this was basically about an oil tanker. Right? Remember? The defendant sold an oil tanker described as lying on Jorman Reef of Papua, but actually there was no such thing. Okay? So that means the defendant, I'm the seller, right? So I sell you, you are the plaintiff, I sell you an oil tanker which was basically lying at Jorman Reef of Papua. So the buyer said, okay, right, I will buy. So he agreed to buy, and he incurred considerable expenditure in sending a salvage expedition to look for the tanker. Right, so the contract was already entered into. So the buyer wants to go and find where the tanker, so he must get some salvage companies to go and find. You know, the sea is so huge. You saw the MH370. They still cannot find, right? how many millions of dollars they spend, they still cannot find. So the same thing happens here. So here they have to spend money to go and find where the location is. Okay, or location at Jorman, Papua, so they have to go and find the oil tanker. So but what actually happened? Right, there was in fact no oil tanker, nor any place known as Jorman Reef. You understand? That means there was no such place called Jorman Reef and there was no such oil tanker. So therefore, the plaintiffs, the person who bought the vessel, brought an action for breach of contract because a contract was entered into, for deceit and negligence. Right? The trial judge gave for the plaintiffs. That means he told the plaintiffs, yes, the claimant to succeed because the other party had breached for deceit. You have lied. He held that Couturier and Hastie obliged him to hold that the contract of sale was void and the claim for breach of contract failed. Right? So therefore both the parties appealed. This fellow appealed and the other party also appealed. The High Court of Australia stated that it was not decided in Couturier and Hastie that the contract in that case was void. Right? The question was whether it was void or did not arise. If it had risen, as in an action by the purchaser to damages, it would have turned on the ulterior question under whether the contract was subject to an implied condition precedent. In the present case, there was a contract. What was the contract? Between the buyer and the seller. Right? There was a contract to sell the vessel. And the commission contracted that a tanker existed in the position specified. Right? So the commission said there was a tanker in the position specified. So since there was no such tanker, there was a breach of contract. And the plaintiffs were entitled to damages for that particular breach. You understand? So that is the point. So in that case, so the same thing, Couturier and Hastie, when a contract was made, there was nothing in existence. You understand? Both of them believed that the corn was on board the vessel. But unfortunately, there was nothing there. Correct? So similarly, the same thing happened here. So in Macquarie's side, okay, there was no tanker and there was no such place called that. Whereas in Couturier and Hastie, there was such a place called that. You understand? So in that particular case, there was such a place, but in this one, there was nothing to that effect. So on that base, in this case, the court held, yes, there is a contract, and since you lied, there was a breach of contract, and the claimant can claim damages, or he can claim monetary compensation for the loss that he had suffered, for the breach that you have gone through. Okay? So that is what res extincta. That means where the where the subject matter is not existent. Right? So in this case, the tanker was not existent. But in that case, the contract was not void. But in the other case, in Couturier and Hastie, the contract was void ab initio because at that point of time, both parties thought that the corn was on board the vessel, when in fact it actually was not. Okay? Clear on that now? Right. So that is the first part. The second part is what you call resoir. So what is resoir? Resoir basically means, okay, when a person makes a contract to purchase something which was already his. You understand? That means this is my product. I didn't know it is my product. I'm selling it to you. You understand? So this is my file. Right? So actually it is my file. But you are holding it and you are now selling it to me. So I'm buying what is actually mine. You understand? So that is what it is. Where a person purchases a particular item, a particular product which is actually his. Right? So in those circumstances, the contract is void and I can get back my item without paying. Okay, so this is basically about a license. Right? So here the uncle told the nephew, right, not intending to misrepresent anything, right, but being in fact in error, that he, the uncle, was entitled to a fishery. So then the uncle told the nephew, okay, actually there's no misrepresentation. I think he also felt that it was his. So he said that he was entitled to the fishery, meaning he has a license to do the fishery for himself. The nephew, after the uncle's death, acting in the belief of the truth of what the uncle had told him, entered into an agreement to rent the fishery from the uncle's daughters. You understand? So the fishery actually belonged to the nephew, but the uncle thought it belongs to him, so he told it is his, right? So after the uncle died, nobody wanted to do the fishery, the daughter couldn't do, so the nephew wanted to rent the fishery, right? So that's what he said. So he entered into an agreement to rent the fishery from the uncle's daughters. However, the fishery actually belonged to the nephew himself. The House of Lords held that the mistake was only such as to make the contract voidable. If parties contract under a mutual mistake and misapprehension as to their relative and respective rights, the result is that that agreement is liable to be set aside as having proceeded upon a common mistake. Okay, so that is what they say. At common law, such a contract is more correctly described as void, there being in truth no intention to a contract. So in those circumstances, it becomes void. Okay, so that is the case with regards to common mistake. The quality, I'll come back. I don't think I've done the quality yet, right? Am I right? I'll come back quality later. So that's an important area. I'll just highlight to you in a while. Okay, right. The other factor is mutual mistake, right? So mutual mistake is what? Mutual mistake, what is the case? Raffles and Baichelhaus. Right, do I have it? Raffles and Baichelhaus. Right, that's on page 109. Oh, sorry, 100. Right, where the parties are at cross purposes. Right, a mutual mistake is one where both parties fail to understand each other. Right, so as I told you, the case of Raffles and Baichelhaus, where we are talking about a vessel ex-peerless, which was basically coming in different times. The buyer thought it was coming the one in October, the seller thought the one is coming in November. Right, so both parties fail to understand the issue. Right, where parties misunderstand each other's intention and are at cross purposes, the court will apply an objective test and consider whether a reasonable man would take the agreement to mean what one party understood to mean or what the other party understood it to mean. If the test leads to the conclusion that the contract could be understood in one sense only, both parties will be bound, right? Look at the case of Raffles and Baichelhaus, so that's what I did. Plaintiff agreed to sell cotton to the defendant, which was to arrive ex-peerless from Bombay. Right, when the cotton arrived, the plaintiff offered to deliver, but the defendants refused to accept the cotton. Defendants pleaded that the ship mentioned was intended by them to be the ship called Peerless, which sailed from Bombay in October, and that the plaintiff had not offered to deliver cotton which arrived by that ship, but instead offered to deliver cotton which arrived by another ship also called Peerless, which had sailed from Bombay in December. So both parties misunderstood what it was. So judgment was given for the defendants. Right? It was held that there was nothing on the face of the contract to show which Peerless was meant, so that there was a plain case of latent ambiguity as soon as it was shown that there were two Peerlesses from Bombay, and parole evidence could be given when it was found that the plaintiff meant one and the defendants the other. If that was the case, then there is no consensus and therefore no binding contract. You understand? So you cannot have any contract, so both parties are not binding each other. Right? So that is what? Mutual mistake. Right? And now what is unilateral mistake? So unilateral mistake basically means what? Where one party is at fault. Right? That means one party is fully aware of what it was. Right? So the case, page 95. The case of unilateral mistake is where one party is mistaken. Right? So one as to the terms of the contract, where one party is mistaken as to the nature of the contract and the other party is aware of the mistake. Right? Then the contract is void. So remember, for the mistake to be operative, the mistake by one party must be as to the terms of the contract itself. Right? So those are the two cases, and then the case you can look at is Webster and Cecil. So I think that is the one I gave you a simple explanation of that the last time. Defendant, having refused to sell some property to the plaintiff for £2,000, wrote a letter in which, of a mistaken calculation, he offered to sell it for 1250. Plaintiff accepted, but defendant refused to complete. Romilly refused a decree of specific perform, because that means what? He actually refused for 2,000, right? Then subsequently he sent a agreement to say that he offered to sell it for 1250. So what actually he wanted to sell it for? 2250. You understand? That was the amount he wanted to sell, but he just missed it out, so he put 1250, which the other fellow straight away took. Right? You understand now? Huh? Because the point is he already refused at 2,000. So how can he agree at 1250? Correct. So you cannot agree at 1250. Huh? So that was what the particular case of mistake as to the unilateral mistake, where one party makes the mistake and the other party is aware of it. Right. The other point that we also wanted to discuss was the point relating to mistake as to the identity. Identity of whom? Identity of the person, right? So mistake as to the identity of the person. So when we say mistake as to the identity of the person, right? So remember there were two things we discussed, two aspects of it. One, the two cases of Cundy and Lindsay, and the case of Ingram and Little. The other is the case of Lewis and Avery. And what's the other case? Phillips and Brooks. Right? You understand? So, in the case of Cundy and Lindsay, what happened? In the case of Cundy and Lindsay, was the person in front, was the person before them? No, it was not no, the person was not present. So, it was basically absentee. Whereas in the other one, it is in present itself. That means before themselves. So in the case of Cundy and Lindsay, the person was not there, right? But the seller wanted to enter into a contract with the person named in that particular contract, right? That means he wanted to enter into a contract with Blankiran and not Blanken the rogue. That means right from the beginning, his intention was to enter into a contract with Blanken. Right? Blankiran and not Blanken. So on that basis, we can say the contract is void for mistake. So once it's void for mistake, that means he can recover the goods from the other side. Okay? So that is the part relating to Cundy and Lindsay. But when you look at what's the other case? What's the other case? Cundy and Lindsay, Lewis and Avery. Sorry, what's the case I said? Just black out for me. Phillips and Brooks. Right. Phillips and Brooks are. What were the facts of Phillips and Brooks? Can you recollect? I think I told you the example, the jeweler want to buy the ring, remember? So in that case, the contract was between whom? Was it between Sir GB and the jeweler? No. It was the person who was before him. You understand? So in that particular case of Phillips and Brooks, identity was not an issue. Correct? You understand? So identity was not an issue. So it is basically they wanted to enter into a contract with the person who was before them. That was the main thing, right? So that means they only wanted to enter into a contract with the person who was before them and not what? And not with Sir GB. Right? The identity only came after the contract was entered into. Okay, so since the identity only came about after the contract was entered into and not before, right? So on that basis, what happened? The contract is voidable. Right? So the contract is not void for mistake but voidable. So when we say not void for mistake, that basically means, that means you have to enforce it until it is avoided by the party concerned. Right? So how must he avoid the title? He has to make a police report. But if the rogue sold the ring before the police report is made, then the buyer of the ring will have good title. You understand? So he must avoid the contract before the ring is sold to another party. You understand? But if the ring is already sold to the other party and then you make a report, then you have got no rights. Right? So that means the third party has got right, he has taken title to the goods and you cannot recover. Okay, so that's why they say you have an voidable title, you must avoid it before the what? You must avoid it before the goods are sold to the next party. Right? So that is basically a case of inter presente. So inter presente basically means where the persons are there. Right? Where the persons are before them. So the contract is whether it is between the person before them or the other way around. So in that case, the court held it is a voidable contract. Right? So similarly, the case of Lewis and Avery. Right? But Ingram and Little is a questionable case, remember? Right? It was also, the person was present, but the issue here was what? The issue here was because of the fact that these are the sisters, quite poor, old sisters, one checking here, one checking here. So they were all checking to see that the person was the one whom he said he is entering into a contract. So in that case, they were able to obtain that. But if you look at 99, Lewis and Avery. So same thing as Phillips and Brooks. Lewis advertised his car for sale. A man who turned out to be a rogue called on Lewis, tested the car, and he said he liked the car. He called himself Richard Green and made Lewis believe that he was a well-known film actor by that name. They agreed a price and the rogue wrote a check. Okay? He said he wanted to take the car at once. Lewis asked for proof of identity and he was shown a studio pass which bore the name Richard Green and a photograph of the rogue. On seeing this, Lewis was satisfied and let the rogue have the car and logbook. Right? You saw the photographer. The check was dishonored. That means the check bounced. Meanwhile, the rogue has sold the car to Avery, who bought it in good faith and without knowledge of the fraud. Lewis brought an action for the conversion of the car. That means he said, you did the wrong, so you want to get back my car because it is basically mine and what has bounced, the check has bounced. But here, what the court held was, so he wanted an action. It was held by the Court of Appeal distinguishing and doubting Ingram and Little. So what did Ingram and Little say? What did Ingram and Little say? Ingram and Little very clearly say what? That they are entitled, the contract is void, correct, for mistake and they recover the car. Right? In that case also it was basically inter presente. So inter presente means the persons were still presenting before him. You understand? So if on that case they are able to succeed, then in this case what happens? So that was the position here, right? So here it is also inter presente, right? You are coming to me and basically you are showing me. So that means I've already agreed to sell the car to the person who is in front of me. Right? You see, they agreed a price. So that means contract already concluded. Then the rogue wrote out a check. You understand? So that's the time he wanted to find out identity, and he gave a studio pass saying Richard Green and a photograph of the rogue. Right? So that means he said, okay, proceed. So actually there was a fraud. Okay, so the fraud was perpetrated by the rogue, rendered the contract between Lewis and the rogue voidable and not void because where transaction had taken place between a seller and person physically, right, there was a presumption that the seller was dealing with that person. Okay, so that is the position. Okay, so there is a fraud on the part of the seller. Okay, so we will have to look at that aspect of it. The second aspect, Lewis failed to show that at the time of selling the car, he regarded the identity as vital important. So in that case, identity was not an important factor for Lewis. You understand? So since that was not an important factor for Lewis, so therefore he was not able to succeed. Right? So they say if the transaction is totally ambiguous, right, under his objective test, there will be no consensus agreement and the contract will be void. So that is the point when we talk about specifically, right, on what shall I say, on the idea of non-mistake as to the identity of the person, right? So mistake as to the identity of the person, as in the case of Lewis and Avery. Okay, so that was it. Okay, same thing, we look at the other case on page 100. Lake and Simmons, I just run through the case. A woman, Esme Ellison, who had bought certain goods from the plaintiff jeweler on previous occasions, okay, told him that her husband, right, Vanderbilt, wished to give her a pearl necklace, believing that she was the person he represented, right? That means she's coming to say, I'm the wife of so-and-so. You understand? I come and see you, I say, I'm the wife of so-and-so. I want to do this, I bought so many things, and now I want to look at some more jewels. So if you think it was, if the seller thinks, yes, I think this lady is the wife of so-and-so, very popular, very rich man, then there's no problem, he will try and give as much credit he wants. Right, so that's what they happened. So this woman who had bought certain goods from the plaintiff jeweler on previous occasions. So sometimes what happens is, you must come and make yourself well known. Right, today if I want to steal from you, can I come today and steal? Cannot. I must come make friends with you. Right, I say I'm so and so. So every time I buy, so you have a trust in me. So after you having a trust in me, even if I say I want credit, you will give credit. You understand? So in this case, that was not the issue. But the point is that there was that point whereby she said that she is the wife of Vanderbilt and who wanted to give her a pearl necklace. So at that time, so what happened to our seller? Seller was very happy. So he thought she was the person who was representing the husband. So he allowed her to take 2 necklaces to show her husband. Right? In fact, Esme was not Vanderbilt's wife. Having obtained the necklaces, she ran away and sold it to somebody else and kept the money. The plaintiff, right, so the hotel, brought an action against his insurance company, right, who refused to pay as the goods had not been entrusted by him to the thief. Right, so it was held by the House of Lords that in obtaining the necklaces in the way that she did, Esme was guilty of larceny at risk. Right, therefore the plaintiff permitted her to take the necklace. There was no consensus. Right, so therefore the plaintiff was able to succeed. Okay, right, so that was the position. So that means he believed, right? Right, so she sold it. Okay, so that was the part relating to mistake as to the identity of the person. So we are talking about 2 aspects, the inter presente and inter absente. So inter presente means you are entering into a contract with the person who is before you, right? So sometimes you can gauge whether he has the requisite caliber. Now, as I told you earlier, right, to highlight or to understand the case of what? Shogun Finance, right? So that is a case, right? I think your textbook will have, and also this book will have. So if you have, can I just run through very, very quickly, right? So I just run through the law as stated here, and then I will go through the principles here. Courts often found that in seemingly similar circumstances, there was a contract. So a mistake as to the attributes of identity, right, as to the type of identity, such as creditworthiness, will generally be insufficient to render the contract void. In some circumstances, the contract is made inter presente. Presente means before, together with them. That is to say face to face. So in that case, identity does not become an issue, right, because you are entering into a contract with the person who is there. And the vendor meets the rogue and contracts with him. In these cases, courts have frequently said that the rogue is identified by sight and hearing, Phillips and Brooks, and Lewis and Avery. So these are the 2 very important areas. okay, how you are going to work on. So both are inter presente. So in that case, as long as you are in present, so you cannot enforce. When the parties are before each other, a presumption arises that the mistaken, deceived party intended to contract with the person before him, and a contract had arisen. The existence of such a presumption had been doubted in the past, but accepted by the majority of the law lords in Shogun finance. Right? So that was what now you are going to take on. Okay? As in the case of Phillips and Brooks and that. So it is becoming a bit more of a challenge. Right? So in Shogun finance, what happened? A rogue entered into a written contract of hire purchase with Shogun finance to purchase a vehicle on credit. Okay? So the rogue fraudulently assumed the identity of another person. So he came in as if he is Mr. B when he is only Mr. A. Majority of the law lords found in these circumstances, identity was critical to Shogun finance. Right? So identity was one very important factor. Right? So it has been critical because it was necessary for them to check the credit rating of their potential borrowers. A parent contract was a nullity due to the mistaken of identity and an absence of consensus. Majority also approved of a presumption that in the face-to-face cases, the party deceived, right, intended to deal with the person physically before him, and the result is a formation of a voidable contract. Okay, so what is the main thing? So in Shogun finance, it was not a case of face-to-face transaction, and presumption did not take place. So there was no face-to-face. It was basically by a written contract. Right? So it was a written contract. So do you think that the identity of the person was a point to make? Yes. Right? So here, so unlikely in will be followed. Unlikely to. So they may not follow Ingram and Little. The dissenting lords. So there are 5 of them. 3 will be dissenting. If you're talking about 3 or 2, depending on how it is. Disapproved a distinction based on whether the rogue's fraud was perpetrated in writing or face to face. Okay? So that part you can read. Okay, so the distinction you can keep in mind between contracts and face to face and contracts at a distance, where the apparent contract is formed at a distance and probably in some form of writing, right? It is likely that the apparent contract is what? Because for mistake, for this to occur, the identity of the party must be critical in the formation of the contract. Where the contract is formed between parties who appear between each other, presumption arises, mistaken party intends to contract with the person who is before them. Right? So that is it. So if you look at the case of Shogun finance, so it will take a different turn from that of Lewis and Avery. Okay, so you'll take a different turn and you can specifically say that the contract will be effective. Okay, so that is the case of what shall I say, the case of Shogun finance. So just have a chance, if you have a chance, just to read and understand it. So sometime you may have to reconcile it, so that the questions can come up. So you have to reconcile it. If you're going to reconcile it, how you're going to do so. So you may be able to highlight that particular area. Okay, right. So generally, and then the last one that we did was what? Was mistake as to the identity of the document. Remember? So that means that you are basically telling, right, the document that you signed is not yours, or is not what you would want to sign. Right? So the document is not the one that they said you will be signing. That means they are trying to come back with something different. Right? So that is the document. So that is document as to the mistake as to the nature of the document. Right? So what is the case? What is the case? Anglia Building Society and Saunders, right? Or sometimes you call it Galley and Lee, right? So in that particular case, right? So what happened? in Galley and Lee, right? So you remember the old lady and the nephew and the rope. Did I mention that to you? Did I mention that to you? No. Galley and Lee, right? Remember, she broken her specs, right? So as she broke her specs, she could not read. So the nephew's friend come and ask her to sign. When she asked what it is, he said, "Oh, this is basically, a guarantee or something like that." When actually it's a document assigning the interest to the rope. So the fellow used that to go and collect money. So the bank wanted to recover the money. She don't have, she sued. By which time she died, but the court held what? In that case, the old lady could not just have signed it. She should have what? Made clear what the document is before she signs. So since she did not make clear what the document is before she signed, therefore she will not be successful. Okay, so that is basically where we stopped, right, with regards to mistake. Now, the other factor that you need to look at may not come out, sometimes it does come out, right? And that is mistake as to the quality of the goods. Okay, so remember, so we got mistake, got so many times. Mistake as to the what? Mistake as to the identity of the person, mistake as to the identity of the document, mistake as to the quality of the goods per se. So when you look at mistake as to the quality of the goods, right, so there are some cases that you will have to note. So what are the cases that you will have to note? If you look at page, right, there are a few cases here, right? Page 89 starts it off, but from there we just move on. So what do you mean by mistake as to the quality? Very difficult, right? So when you're buying a particular product, so whether it is original or is fake, you understand? So we are talking about originality. So is the goods original? So is it something that's original, or is it somebody of a fake fella who drew it, right? So if the fake fella is drew it, then you can say right from the beginning it is fake, and the contract may not be considered. But sometimes everything finishes, you already consume, etc., etc., you already use it, then it is quite difficult. So when you come to quality, how are you going to identify? Right? Remember when you talk about Mona Lisa, you can say Mona Lisa written by the, who did the Mona Lisa? Leonardo da Vinci, correct? Right? So that is what he did. Have you all seen the Mona Lisa in Italy? Actually I went last year, was it? Last year June. Just a small one. It is specifically placed. Where is it? In Paris. Right? So it was in Paris. It is in Paris. So in this particular case, you're talking about the quality of the product. Right? So sometimes all the fake ones, you understand? But now lesser already, last time a lot. So you say, oh, this is drawn by Mr. X. So he is the main person. But in actual fact, he was not. And you didn't know. You also believe it was done by Mr. X. After few years later, then you find out, oh, it is not done by Mr. X. So therefore the value has gone down. Right? So can I now sue the fellow who sold me the goods for mistake as to the quality of the goods? You understand? Are you able to understand? So that is what the concept is going to be. Identity, very simple, as I said. Identity, very simple, because you got the inter absente and inter presente, and from there you work on. But in this case, it will be slightly different. So quality is sometimes very subjective. So how much good quality is good quality, how much not so good quality. Maybe if it's a branded good, it is different. Right? But there are also other non-branded goods which are equally good as the branded goods. Correct? Right? So there are also other things which are equally good as branded goods. Right? So that's what we are just going to run through very quickly. So what is a mistake? So that's why I say it's limited to very narrow limits. So very, very subjective, very simple part. That's what you're going to look at. So from now, a broad aspect, you're going to go into a small aspect. A mistake will not affect assent unless it is mistake of both parties. Okay? And is to the existence of some quality which makes the thing without the quality essentially different from the thing as it was believed to be. Okay? Right, can you just look at the wordings and tell me what it actually means? Can anybody? Look at the meaning. Huh? So what does that basically tell you? A mistake will not affect assent unless it is a mistake of both parties and is as to the existence of some quality which makes a thing without the quality essentially different from the thing as it was believed to be. Anybody? Okay, so that means when you talk about the quality, right? So look at a few cases, right? The Bell and Liver brothers, okay? So we are talking about the contracts, service contracts. So Bell and Liver brothers, very simple, right? Let me just highlight the facts for you. So in the case of Bell and Liver brothers, right, so in that particular case, okay, you got a plaintiff contracted with the defendant, okay, who were to add defendant 1, defendant 2, right? So that means chairman and vice chairman of a subsidiary company, okay, plaintiff company, subsidiary company, right? So subsidiary company means what? Who is in control of the subsidiary company? Who is in control of a subsidiary company? Hello? Plaintiff subsidiary, that means the plaintiff company subsidiary company means the plaintiff company owes more than 50% of the shares in the subsidiary company. Or it can, as long as it owns more than that, even 100% can, right? So therefore, this company, right, is a subsidiary company, right? So this is the plaintiff company which owns, right? So D1 and D2 are the directors, and two directors, chairman and vice chairman of the company, right? Okay, so subsequent to that, right, so agreed that C and vice chairman, right, should resign. Okay, so it was agreed that these two fellas should resign from their post as directors. You understand? And they were what? Given a lot of compensation. You understand? So that means they were directors, chairman and vice chairman, and it was agreed that they will be given what? Compensation, they should resign. Okay, so that has already been done. So they have already resigned. Huh? Okay, should resign. What happened subsequently was, it later transpired, after some time they found out that the chairman and vice chairman, right, had engaged in private transactions. Right, that means they had taken secret profits. Were they? That means they have taken bribes. You understand? So if they have taken bribes, what is the effect of taking bribes? Can I sack you? Yes. You understand? So if I found out you have taken bribes, I can sack you. But must I give you compensation? No need. You understand? But now before they knew it, they say you resign, I give you compensation, right? But subsequently they found out that what? That these fellows had taken bribes. Right? So if that is the case, then automatically they can be sacked and no compensation could be paid. Are we clear on that now? So that was the position here, right? So it later transpired that the defendants, without the knowledge of the plaintiffs, had engaged in private transactions resulting in a secret profit to themselves. These transactions constituted breaches of the defendant's contracts, which would have entitled the plaintiffs to terminate those contracts if they had known of the transaction. That means I can just sack you, no need to pay you anything. You understand? So what happened? The House of Lords. So 3-2 means what? It is a majority decision. That means usually House of Lords will be 5. Right? Court of Appeal will be 3. Right? So House of Lords 5, 3-2 means majority. 4-1 is also majority. And 5 is unanimous. Right? If 5 of them decide on one point, on one type, then it becomes unanimous. So it was held by the House of Lords that the erroneous belief on the part of both parties to the agreements that the service contracts were determinable except by agreement did not involve the subject matter of the agreements, but related to the quality of the subject matter, and so was not of a fundamental character as to constitute an underlying assumption without which the parties would not have entered into the agreements. Therefore, the plaintiffs were not entitled to succeed. Right? That means what happens here? That means the belief on the both parties. That means between whom? Between the plaintiff company and the directors. You understand? So that means both parties believe that the service contracts means that the contract between them were only terminable, right? Were determinable. That means you can terminate, right? Except by agreement. That means you can only terminate by agreement, basically, because both parties agree to terminate. So only on that basis, right? Did not involve the actual subject matter of the agreement. That means it was never involved of the transactions or the secret profit that they take, right? But merely related to the quality of the subject matter and was not of such a fundamental character. So on that basis, the court held that the plaintiffs cannot. So that was the main factor here. So you look at the quality of it. So right from the beginning, what was the intention? So that was what it was basically done, and the parties were able to, cannot recover. So who succeeded? The two vice chairman were able to go scot-free. So they were still entitled to the claimant. So this fellow wanted to recover back the money that he paid, but the court said no. Now, Lord Denning, as I mentioned to you, he's one of the better judges in his time. Very, very knowledgeable judge. And most of the time, he's always for the poor fellow. Try and help. He will always try and help the poor fellow. Can you recollect the case of George Mitchell and Finney Lockseeds? Remember? The fundamental breach case? It was he who basically ruled in favor of the farmer. Right, here Denning said, let me first consider mistakes which render a contract nullity. Is mistake a nullity? If you find mistake, is that contract a nullity? Yes, correct. If there is a mistake, it is null and void. Correct? So it is void when? Void right from the beginning. Right? So it is void ab initio. Right? So that is what it is. All previous decisions on this subject must be read in the light of Bell and Liver Brothers, as we did earlier. The correct interpretation of that case to my mind is that once a contract has been made, right? That is to say, once the parties, whatever their inmost states of mind have to all toward appearances, agreed with sufficient certainty in the same terms on the same subject matter, then the contract is good unless and until it is set aside for failure of some condition on which the existence of the contract depends, or for fraud, or on some equitable ground. Neither party can rely on his own mistake to say it was a nullity from the beginning, no matter that it was a mistake, which to his mind was fundamental, and no matter that the other party knew he was under a mistake. That means you go right from the beginning, you go on to the contract. You understand? So what is the contract? So in the case, was there agreement between the plaintiff company and the two directors? Was there an agreement? Yes. To what? Agreement for the directors to resign and these fellows will pay compensation. So that will take precedence. So you cannot come after that and say there was a mistake. You understand now? So that is what the main point was made. Just remember that. Under normal circumstances, we can say, yes, a contract is void for mistake, etc., etc. Right? But in these circumstances, it is quite clear. Right? That means once a contract is entered into, the contract takes precedence. So you cannot later come back and say, hey, after the contract, 6 months after the contract, oh, you've taken bribes, I want to cancel it. Cannot. You understand? So at that point of time, so just repeating what it is said again. Right? He says, all previous decisions must rest in the right of bell and limb. So what is the interpretation? Once a contract has been made, that is what? Between the company and the two directors. Remember? We are going back to that. That is to say, once the parties, that is the two parties, the company and the directors, whatever their inmost states of mind have all toward appearances, agreed with sufficient certainty in the same terms on the same subject matter. So both of them agreed to what? Both of them agreed that the directors will resign and they will get compensation. Right? Did the company agree to that? Yes. Did the directors agree to that? Yes. Okay? If that's the case, then the contract is good. That means contract is good means what? That means is the contract valid? Yes. That means I will resign as I promised, you give me the compensation. So that means the contract is effective. So I can rely on the contract. Okay, so that's why they say the contract is good unless and until it is set aside. That means it is cancelled for failure of some condition where you fail to do certain things. Right? So it can only be set aside when you fail to do certain things. Right? Okay, for failure of some condition on which the existence of the contract depends, or for fraud, or on some other equitable ground. That is after that. But neither party can rely on his own mistake. So now the plaintiff is saying what? Oh, sorry, I mistake. I pay you my mistake. You understand? Because only now they found out that he has taken secret profit. You understand? After paying the money and all that, he say, hey, sorry, I make a mistake. You know, it was a mistake on my part to pay you. I only now realize that you have taken bribes. So if you have taken bribe, automatically you will not be given anything, and you will basically ask to go. So that's what he says. So neither party can rely on his own mistake to say it was a nullity from the beginning. No matter that it was a mistake